So this is a story about Yelp and a law firm. For those of you who are not familiar with Yelp, Yelp is a service that you can post various things to, reviews about, your plumber, your electrician, apparently your lawyer, your doctor, different restaurants, different stores, etc. So this is a story out of the LA Times from September 18th of this year, and it involves a lawyer and her former client. Now, a lawyer named Dawn Haskell sued her former client, Ava Bird, for defamatory statements that were posted on Yelp about her client experience. Now, according to the story, Miss Bird was a client of Miss Haskell's law firm for approximately 25 days. And during that time, Miss Bird didn't return any phone calls. She missed important meetings. She didn't return emails to the firm. So Miss Haskell, the lawyer, basically sent Miss Bird a polite letter withdrawing as her attorney, basically firing her client, and advised her to find another attorney. A few months later, Miss Bird posted on Yelp stating that Miss Haskell had made a bad situation even worse by reneging on the case. Miss Bird also posted that Miss Haskell was incompetent. So Miss Haskell sued Miss Bird, asking for an injunction against her former client for defamatory statements. The suit was for approximately $550,000 in damages. And Miss Haskell ended up winning by default because Miss Bird never answered to the lawsuit. The judge in this case ordered Miss Bird to take the post down off of Yelp, but the judge also ordered Yelp to remove the post from their site. Here's the thing. Under Section 230 of the Communications and Decency Act, Yelp, as a provider of these services, is immune when they publish information for others. Here it is, Section 47 U.S. Code, Section 230 of the Telecommunications Act. This act was published in 1996. And many say that the original reason for this act was to restrict free speech on the internet. And Section 230 was not actually in the original version of this act. When the bill was passed by the Senate, it was passed without this section. This section was added by the House of Representatives in conference after the Senate version had passed. And here's a highlighted portion of the act that tells you that providers like Yelp, Wikipedia, WordPress, things like that are immune from these types of orders. So internet companies, as I said, like Yelp, Wikipedia, WordPress, anybody who basically publishes information for others on the net would not be in existence, at least these companies say that, were it not for this particular section of the act. So here we are, for instance, Wikipedia said that they would be caught up in every little lawsuit when a good faith post had inaccuracies. This is why I tell you students not to use Wikipedia as a primary source, because people post to Wikipedia, but many of these posts can be inaccurate because anybody can post to it. That's why it's always good to go to your primary sources when you want to get information. Again, there's another company like WordPress who also publishes like Wikipedia. They say they're dependent on this section as publishers of your posts, your articles, etc. on the internet. An example, Yelp said, is that they'd be forced to take down every negative comment, even if the comments are legitimately negative. So Haskell's lawyers are saying that this ruling is actually no big deal, and it changes nothing for publishers of internet posts because these posts were first ruled defamatory, and because they are defamatory, that's why Yelp is being ordered to take them down. But Yelp is saying that this is actually an attack on the First Amendment and free speech on the internet. It could extend to any posts that are deemed to be negative. According to the news story, Yelp is saying that by allowing Yelp to get brought in between the order between poster and postee, this is a roadmap for those who want to squelch or stop free speech on the internet. Because remember, Yelp was never a party to this lawsuit. They never actually had a hearing before the judge where they were able to say why they agreed or disagreed or make any kind of argument. This would mean, according to Yelp, that any newspaper or any publisher could be ordered to take down posts or take out things that are deemed to be negative. That's why this case is going up the chain of the appellate courts in California, and everybody is watching what's going to happen. So we're quoting directly from the article now, and this is basically highlighting the one of the main issues in this case for Yelp, saying that if a newspaper, for instance, is ordered cannot be ordered to take down a libelous comment without an opportunity to be heard, and this is basically an issue that was brought up in an amicus letter, similar to an amicus brief, by some people who are watching this case. And for those who don't know what an amicus letter or amicus brief is, it is someone who's not a party to the case and not solicited by a party, meaning that Yelp didn't say, hey, come help us out. Ms. Haskell didn't say, hey, come help us out. But they see the issue as something so important that they feel that they need to also address the court, so they'll have other views of how to decide this case. And like I said, in this particular case, this amicus letter was actually written by this UCLA law professor and 12 other law professors because they see it as an important First Amendment issue. Again, I've highlighted at the bottom, they're saying that the law professors are saying that, look, if a bookstore cannot be ordered to take out an allegedly obscene book, or an art gallery cannot be ordered to take down an allegedly obscene painting without having a hearing before the court. And this is their key issue. Hearing meaning that they haven't had an opportunity to argue, they haven't had an opportunity to present their side. They see this as an important First Amendment issue dealing with the internet. And this is not the only case that's dealing with a particular issue. There's also another case, another story, I should say, from the Washington Post from February 2014 involving negative comments that were listed on Angie's List and Yelp about a contractor. And this particular contractor was actually able to have a $750,000 lawsuit about these particular comments. So this is an ongoing issue about how to control the internet and how to control speech on the internet, and both sides are watching it very closely.